Hello, Realty Pros, and welcome back to another evening's mastermind training session. And we're just almost overflowing because we were privileged to have Velocity with us this afternoon for this afternoon's Realty Talk. And we are privileged again this evening to have Mr. Glenn Donaldson of Velocity Title here with us for this evening's mastermind training. And so we're not going to delay anything. We're going to go ahead. We're going to turn it over to you, Glenn. And if you need me to share something, let me know, and I'm more than happy to do so.
Yeah, well, I think it's a good idea. If you could just have the contracts ready to pull up in a bit. But before we get into that, the other night when we were at, that wonderful event and end of year event with the awards and everything, I spoke briefly about what has commonly now been termed the CAT case by the Anne Arundel County Circuit Court. And we resolved that case this last week. And the reason it's so important is because of the implications that it had to the real estate professionals. And I want to touch base on it tonight for just a few minutes, because I think it's critically important that you guys have sort of a feel for what the courts are looking at in terms of responsibilities for real estate agents in transactions and responsibilities for homeowners and condominium associations. So let's talk about it just a little bit. I'm going to give you the background, right? This property was a property in Crofton Meadows, and it is a townhome. And in this townhome for the last 22 years, an elderly woman lived there with more than 40 cats in the house. And not to get too deep into the woods relating to all of the legalese about it, but the main issue was the house had been saturated in cat urine and feces for nearly 22 years. All of these cats had burrowed their way through the walls and gotten into the HVAC heating and air conditioning systems and soiled this home to the extent that the homeowners association had issued violation notices against the property and the homeowner. When that happened, the neighbor to both sides of this townhouse also filed complaints to the county because the noxious fumes from ammonia and cat urine were so bad that they couldn't even have guests in their home. And one of the neighbors had wanted to have a Super Bowl party, and the people came, the guests came, and literally left within about an hour's time because it was so bad. He filed a complaint to the county and the homeowners association. The woman was elderly and she had been a hoarder. Her family finally came, got her out of the house, and the house was auctioned. At the auction, a couple of guys that came, created an LLC and came in to flip the property, clean it out, fix it up, flip it. Well, when that happened, they got in over their head pretty quick financially. They could not do what was necessary to clean out that smell. The smell had gotten into the drywall, the 2x4s behind the drywall, the years and years and years of saturation on the subflooring, through the carpeting, et cetera. All of this had to be remediated, and they just didn't have the money. So what they did was they cut corners, and they literally took Glade apple cinnamon liquid, the Glade liquids, poured it into the kills, paint primers, and painted the subflooring 2x4s and back of the drywall, and then painted over that and laid flooring over that. Well, that was a temporary fix. In this process, they made the house look kind of clean. A veteran and his wife came in. He was active military from Fort Meade, stationed in Fort Meade, bought the house, and it looked nice and it smelled a little cinnamony, and they were happy at the time. Let's fast forward. When they bought the house, the homeowners association is required under law, as you guys should know, right? In every contract, a homeowners association or condominium association is required under law to disclose any violations that are currently active against a property. Real estate agent, and I know it's difficult on Zoom to get into sort of the question and answer like I like to do sometimes when we're all in person. But when the real estate licensee takes the listing, they have an obligation, right, under law, under COMAR, to take reasonable steps to uncover any problem with a property that is knowable, known or knowable. So when you're taking a listing and you go and you have guys who are, or girls, you have people who are going to flip this property, there's a couple things going on. Number one, what are the full nature of the repairs that are going to be undertaken in this flip? If any of them require permits, right? And then what's going on with the homeowners association if this property being improved, repaired, is part of a homeowners association or condominium association community? What, if anything, has to happen there? And what are your duties as licensees with respect to that? So fast forward in my case, the homeowners association, right before the sale to my clients, to these veterans, that homeowners association removed the violation from the property, and they said under testimony they did it because they knew that somebody moving into the house would take whatever the measures were to fix it because they couldn't live like that. So they intentionally removed a violation that they had a duty under law to notify a buyer of a known defect that resulted in a violation. So the homeowners association now has committed a fraud. They have concealed intentionally a defect in order for the parties to consummate a sale because they believed it was in the interest of the community to have a homeowner move into this property. Well, the case grows because at that point in time, the neighbor, and it's always the neighbor, talks to the new owner and says, how's the smell? How are you guys doing with that? Because we can barely take it now. And of course, he explains, don't you know this was the cat house? And the old lady they knew nothing about it. All they knew is that they were it was getting worse and worse and worse and worse. Well, at some point, their 5-year-old son starts having some breathing issues and was taken to the medical facility at Fort Meade. They told the medical people at Fort Meade what was going on. Well, the U.S. Army then issued an inspection command of this property, and the U.S. Army commander at Fort Meade condemned the property for any veteran or any active military person from living in this property. You can imagine. So what happens is these people have to move back onto base at Fort Meade, and they have a mortgage with the Veterans Administration. So start to put yourself in the shoes of the real estate agents as all this is going on, and think about, well, what duties do we have to try and make sure that something like this isn't going to happen to my clients? Well, throughout this process, we're in litigation because my clients now have to pay for housing at Fort Meade, and the Veterans Administration has a loan on this property. We ended up negotiating what's called a deed in lieu of foreclosure. And the deed in lieu of foreclosure is where the lender, in this case, the VA, agreed to take title to this property back. Well, not back, but agreed to take title from my clients and waive any claim against the deficiency in the loan. So they allowed my client to get off of their liability and responsibility to pay the mortgage. Now that was a big win, and the Veterans Administration took title back. Well, immediately when the Veterans Administration took title back, this homeowners association, in their great wisdom, decided they were going to reissue a new violations notice against them, and commanded that the Veterans Administration cure this noxious and toxic smell from the cat urine within 30 days. So this all got before the circuit courts in Anne Arundel County. And the judge in the case, when it was briefed, clearly stated that the law imparts a duty on the real estate licensees that were involved and the homeowners association. When these situations happen where there is going to be improvements made, the licensee's duty goes beyond just putting the property into the MLS or taking pictures and putting the sign out in the yard. The licensee has a responsibility to do more than that and to investigate the scope of work being done, any repairs being done, why they're being done, and further, and as we all, I think, should know this now, they have an obligation to make sure the people doing the work are licensed individuals. They have the proper MHIC licenses with the state. In this case, some of the people doing the work were not fully licensed, but they had given false license numbers. And so there were some problems there. The court also said that the homeowners association had liability to the clients because they failed to note on a resale certificate that there was a known material defect in the property. And indeed, they removed the violation when they knew that the problem had not been rectified. So in this case, the court has put a duty on both licensees and homeowners associations to do more than what was done here and to make sure that if there is some kind of a defect in a property that is known, it gets disclosed. Now, we think we all know that, but no, the homeowners association attorneys argued over and over and over again, there's no duty, no duty, no duty, but the court disagreed. So where does this leave, without getting into more of the details of the case and taking the whole night on this one case, where does that leave us in this business and licensees with respect to our duties when both we have a buyer who's buying in a community that has homeowners association, which is almost all communities, or a condominium association. So it tells you you've got to ask some questions and document your questions, right? If you're the listing agent, you want to make sure that you've spoken with somebody at the homeowners association relating to the resale certification and that there are no outstanding issues like liens against the property or condominium laws or homeowner association lawsuits that are active or violation notices against the property and the prior owner. You need to make sure that you've done that call and you've gotten that. If they don't speak to you, then make sure that you've talked to the title company. So if it's a Velocity, Cheryl, or whomever is working on that file, make sure when they get that violation certificate, and I'm going to tell them that this is one of the new duties for them, that resale certificate, a copy goes to you guys because you have now an affirmative duty by the court to know what's going on. So what I'm going to be doing is making sure that in any transaction where there's a condo or homeowners association, when the resale certificate comes in, you're getting a copy. If nothing else, you're going to want to review that and put it in your file. You put it in your electronic file, scan it. That way you can show you've done your due diligence, full stop. And the second thing, of course, is anytime, and I've been talking about this for a while now, anytime that there's a transaction where the property is it's either a flip transaction or the property is being repaired substantially prior to the sale and listing, you want to make sure that we have a sort of a schedule of contractors and repairs that were made so that there's at least some due diligence where you've checked licenses of these individuals, and you can affirm to your clients that you've done that work. The home inspections, of course, if pursuant to a home inspection, if there is something that needs to be corrected, we all know that those are supposed to be done by licensed individuals. So when you're checking those licenses, you want to make sure that you've run that down easily on DLLR, their website. The website is the same one you go to if you're checking your own license status. You can run that down on DLLR. It's an extra step that sort of the regulators and the courts are putting on real estate agents. I don't really love it, but I understand it, and it's kind of the nature of what we have to engage ourselves in representation of other people. I can't tell you how many, and I know a lot of you guys I've talked to relating to some of your clients who bought from sellers, and the property's got problems. And these are non-disclosed problems. And your buyer, of course, comes back to you and says, help, I don't know what to do. This is a serious problem, and we can't afford to make these repairs or afford to do what is necessary to cure the problem. So I wanted to give you the background on that case because at the 12th hour, the parties all came to a conclusion, accepted the court's judgment, and everything was resolved. But nonetheless, in the court, they did, by its ruling, impose what I consider to be a little bit of a new duty on the real estate professionals representing buyers and sellers in homeowners association communities and in condominium association. There is a specific statute in Maryland pertaining to the duties of the homeowners associations and the condo associations. If you have any questions on that, if you've got transactions that are involving something that you might have a question on, let me know. We'll look through it, make sure you've got what you need in your file to protect you and Porterhouse. So guys, let's get to the contract. So we have been in our last classes, right? We have been going through the contract, and I want to do a real quick recap on the distinction here, right, with, there we go, as is properties, all right? So, Anita, if you could pull up the current as is addendum, and that's one too, right there, property inspection addendum. Okay. And I want to do this because I want to be really clear about this issue relating to the true as is provisions versus these home inspection provisions, okay? So if you remember the old as-is addendum, what was happening is, particularly when it was in the time of multiple offers, houses getting under contract within virtually minutes of being listed, many buyers were writing contracts that purportedly claimed to be as-is contracts, right? But truthfully, what was happening is they write this as-is addendum, and I guess you can see this, the old as-is addendum. And if you remember, it says as is without inspections, as is with inspections, and a right to terminate. Well, most contracts were initialed as is without inspections, but buyers would do an inspection for, quote, informational purposes only. And what would end up happening was the buyers would find some things they didn't like in the inspection, and they would come back to a seller and they would say, I know we went as is, but we're going to ask you to repair A, B, C, D, E. And sellers, of course, were getting pissed off. It wasn't truly an as is. Many of these cases, right, the sellers had now the house off the market for a certain period of time, but the realtors were truly, by asking, if they represented the buyer, by asking the seller to make some of the repairs, were doing the best they could to represent their client. So there wasn't really anything wrong with it, but it was deemed by the Real Estate Commission that that was problematic. And the Maryland Association of Realtors, National Association of Realtors, they all determined that that as-is addendum was problematic, and it created uncertainty to a seller, and it was meaningless when the buyers would say it's as is without inspection, but do an inspection that would be for informational purposes only. So what they tried to do was fix that problem, and they came up with our new additional as-is provision addendum, which we know is this one, and the property inspection addendum, which we have up on the board right now, right up on the screen right now. So what has come to my attention a lot in the last few months has been confusion with real estate professionals about the structure of these two addendums. So the question becomes, if you're using a property inspections addendum, you're not going to be using an as-is addendum, and you certainly are not going to be putting additional language in an addendum that says we're going to do as is, but for informational purposes only. So when you've got a buyer who you're representing, and that buyer has concerns about getting this property, and they want to do an inspection, but they don't want to get shot out, because it's my understanding, and I think you guys can speak to this better than me, even though the market has not been great, properties still are selling pretty quick if they get onto the market. And so you may still have buyers who don't want to take a chance on losing out on the contract, so they're writing the as-is addendum, but having an inspection done anyway. Well, that's now problematic, right? Because if the buyers are going to use this as-is addendum, you're going to do that. It is as is. That means all clauses in the contract, and I'm reading from the new as-is addendum, in the contract of sale pertaining to delivery of the property shall be free and clear of trash and debris and broom clean. That is stricken from the contract now. It's deleted. That means the seller has to do none of that. Whatever the condition of the property, doesn't have to be broom swept, it doesn't have to be cleaned out, nothing. Number B, right? All requirements for the seller to comply with orders or notices of violations of any condominium unit owners. And maybe, I just thought about something, and Ethan, maybe we want to go ahead and put that as is provision addendum, if you can, up on the screen, since it is important for us to go through that. If you've got it. It might be additional. Yeah, it's a Maryland Association of Realtors additional as is. There it is. Okay. So by initialing below, you see this deletion of property condition requirements. So what this is saying is that we are deleting, by signing this, any provision in the contract that provides the seller will do anything to keep the house clean or remove trash or debris or anything. So there's A, B, and C here. And when you look at A, it says all clauses in the contract of sale pertaining to delivery of the property free and clear of trash and debris. What that's saying by initialing that is that the seller is deleting from the contract any requirement for them to do this. They don't have to do a damn thing. If you walk through that property and there's trash everywhere, unless you specifically, right, have required them to do it, which you wouldn't initial here, unless if you're asking them to do it, you would leave this on initial, okay? B, all requirements for the seller to comply with orders or notices of violation of any condominium unit owners or homeowners association related to the condition of the property. What that is saying is it ties right into that case. If there's a known violation by the condominium association or the homeowners association, the seller does not have to cure that violation, does not have to cure the violation, but it does not constitute a waiver of any obligation of the seller or rights of the buyer pursuant to the Maryland Condominium Act. And what that's just saying is, because the parties are agreeing that any violation is going to be assumed by the buyer, that doesn't relieve the condominium association or the homeowners association from all of their obligations under the condominium and homeowners association at law. Make sense? So, if there is a violation and your client signs this, that violation runs with the house and it becomes your buyer's responsibility, not the seller's. And then C, all requirements for the seller to comply with violation notices or requirements noted of or issued by any governmental authorities pertaining to the property as stated in seller's responsibility paragraph of the contract. And so that's waiving any obligation of the seller to cure any defect in the property that they are aware of pertaining to any governmental issued violations. This is a real as is addendum. It's, if signed by a buyer, it's relieving the seller of any obligation at all. So if now they do a home inspection for any reason, if they've initialed this as is provision, seller, it's as is, it's really as is. The seller can say to them, no, we're not going to be fixing anything. And if you attempt to walk away based on that, we're entitled to a full retention of your earnest money deposit. So it is, the MAR has attempted to fix this sort of loophole that the buyers were using in the old as is provisions. And now they've gone to this contract. So if your buyer is truly concerned about losing out and they don't want to go with a home inspection addendum and contingency, then they're going to sign this as is addendum. You've got to be able to communicate to them very, very clearly that if that's the case, you guys understand, this is as is. It doesn't matter if the chimney is falling off the house. You're buying the property as is, or you lose your deposit. I'll pause there for a second in case anybody has a question that they want to raise. All good? Okay, because I can't see anybody on the screen. I'm just able to see.
Darlene does have a question.
Yeah, go ahead. I can't hear
Okay.
anybody. Is anybody, Darlene,
So-
did you have a question?
We were talking about bias, but I know when I've done a listing, this is in my my packet,
Mhm.
in my disclosures. So I'm trying to think. Right. Right.
Well,
So,
let me
okay,
ask you, Darlene,
I'm
do
trying
you
to
have
think my
this-
question through.
Sure, no
Because
problem.
if the seller signs this, okay, so I don't think I need, okay, that's
I
not my
don't think you
question.
need this in a
I get it.
seller package.
I got it now. It's not
Yeah.
really a question. I was just trying to understand why was this in the packet?
It really should not be in a seller's package. I think you can tell the seller, hey, look, if you really want no home inspection on this property, let's say your seller is an estate, right? Well, an estate may want no home inspection. They might say, we don't know anything about the property. The person who lived here passed away. We're just selling it as is, period, full stop. I'm not gonna get people in to fix stuff. I'm just a personal representative. I live in Alabama. I'm not coming up to Maryland to fix property. So they want an absolute as is. If that is the case, you want to make sure that your seller puts this in any contract that is presented. They want to counter with the as is addendum. Does that make
Okay,
sense?
and because I do have, yes, 'cause I do have an estate sale that's coming up, and so I will make sure that this is in there.
Yeah, the estate transactions are probably the ones that you really want to at least make a good faith attempt right up front to use this as is, this true as is addendum. For other contracts, for most of them, we're going to be flipping back now and jumping to the property inspection addendum. All right. So, and we touched on this addendum before, but it's worth noting now again, because in cases where there are home inspections now, there's two things I want to talk about. And one is the home inspector's liability for missing stuff. And two is using this inspection instead of or in lieu of the as is provision. So in the main body of your contract, as you know, there's a place to initial where you're going to, buyers are going to request a home inspection. And now the home inspection addendum has all of the material terms contained within it. So right up there, number one, right, it's going to say your home inspection contingency period. So the buyer and seller agree, the buyer at the buyer's expense will have a right within X number of days. So this blank line that you see here gives the real estate professional the latitude to put how many days it's going to be for this home inspection to be done. And the reason it's important is because all addenda to a contract tie back to the first page of your residential contract of sale with the top box that says time is of the essence. So when time is of the essence, any date reduces the contract to performance within that date period. So this, let's say we put in section 1, 7 days, right? The home inspection has to be done within 7 days of the date of the contract acceptance. And you'll have qualified experts to conduct inspections listed below. If for some reason you get to 8 days and the inspection hasn't been completed, if you don't have a written addendum, it cannot be emails between real estate professionals. It cannot be an email from the buyer's agent to the listing agent that says, hey, my inspector's mother died. We need an extra day because he's going to be out of town and he'll get back. And the listing agent says, no problem. I'm sorry to hear that. That's really sad. And they sign off and they think everything's jolly. And now we're on the 8th day. And it so happens that the seller in that interim gets a secondary backup contract that's $10,000 more. So we're in day 8, we have a backup contract for $10,000 more. What do you think that listing agent has a duty, an obligation to do? Anybody want to take a stab at that? So here's our facts, right? Contract number 1, we have a home inspection contingency for within 7 days. Home inspector's mom dies, he leaves town. The agents have come up with an agreement by email that they're going to 8 days. In the meantime, contract number 2 comes in for $10,000 more. What is the duty of the listing agent at that point in time? What do they have to do? Take a shot, somebody.
Hey, Glenn, they need to let the seller know that there's another offer in for 10,000 more, and they could essentially accept that offer because the contract is null and void now.
100% correct on every point there. Thank you, Curtis. Good to see you. How you doing, buddy? So yeah, that's it. That listing agent sent the email saying no problem, good, but didn't get an addendum. So now the listing agent literally has to go back to his or her seller and say, you've got another offer here for $10,000 more, non-contingent. I'm going to advise you to take it. Now, what do you think's going to happen next when that listing agent calls the buyer number 1, their realtor, and says, hey, sorry, we're kicking you guys out. We're accepting contract number 2. And buyer's agent is going to be fuming mad and say, you gave me an email. And I know that buyer's agent, if they would call me and they'd say, what the hell? Look what they did here. Well, you got a problem because you didn't get an addendum. An email between real estate licensees is not sufficient. In fact, it's prohibited to be introduced as evidence in any court proceeding if you were to try to. You can't even present the email because it's not within the 4 corners of this document, which is all that the parties and the courts can look at. There's no addendum. It's not said. Emails back and forth, phone calls, text messages do not suffice to bind a buyer and a seller. The seller can freely take the new contract. Of course, they must return the first buyer's deposit, but they can take the secondary contract. That provision within 7 days right there is material term. Now, what if the time is of the essence provision is stricken? It is strikes through and is initialed by the parties that time is not of the essence, and the same set of facts and conditions occurs. And if time is not of the essence, and the parties have agreed through their agents to extend by 1 day because the facts we told you, the death of the mom of the inspector, well, guess what? Time's not of the essence. The extra day, the seller agreed, would not be material. It would not be a material term. And so therefore, the extension of that extra day is sufficient to bind the parties still, if time is not of the essence. Everybody clear on that issue? And you can jump in if you're not, if you want me to repeat something, but hi. So if you do have a question on that, just jump right in. But if not, we'll just keep going. Let's move now to the scope and the material. Go ahead, Aurelia.
Okay, I do have a question, because maybe you said something, a key term when you said something about the time frame. But I'm
Yes.
thinking that this is something outside of the entire contract, and this applies only to the inspection. And so why would, because I'm thinking that the buyer would then forfeit its inspection, or that it would not count, and not that it would cancel out the entire contract. That's what I'm not understanding.
Sure.
Why would that
So-
happen? You s-
Yeah, because there's a material term of the contract. Material term is some condition precedent. So a contingency is called a condition precedent under law. And what that means is if this condition is not met, then the contract is not enforceable, which means that the parties do not have an actual ratified contract. So where there's a term that's not met, or any defalcation of any term, an addendum. So if you look actually right at the very top of this contract, okay? So Anita, if you could scroll up to the very top of the addendum, I'm sorry, the addendum, not the contract. I apologize, I messed you up. Okay. It says addendum dated X to the contract of sale, right? So this is to the contract of sale, meaning it becomes a part of the entire contract itself. And when something becomes a material part of an entire contract, then if there's a condition precedent within it, it applies to the entirety of the agreement. And Aurelia, that was a great question, because for clarity purposes, what you're saying is, well, why doesn't that just void the property inspection addendum instead of allowing the seller to be able to declare the entire contract null and void? And the reason for that is if there's any material term that has been defaulted upon or non-agreed upon, then you don't have a ratified contract at that moment, and the seller is free to accept another contract. Now, if the seller did not accept the other contract yet, and the buyer came back and waived their inspection, then it could be argued that the remaining terms of the contract are going to be ratified. But that's not the facts we had here. The facts we had here is that there was an agreement just to extend a date on the inspections. Well, nobody talked about anything. Nobody wrote anything down. They just talked about it. And therefore, by day 8, this contract is non-enforceable. It's not ratified. So the intermittent contract from buyer number 2 can be accepted by the seller. I hope that, I know it's long-winded, and I hope that answered the question, because that was a great legal question.
Yeah.
Yeah, I hear the little feedback going on there, but does that, you can just shake your head, Aurelia, did that answer the question?
Yes, it definitely did. I know you mentioned a key word, and that was the material fact. And so now I understand. Thank you.
Okay, you got it, perfect. Good question. So, okay, so we'll get back to the inspection addendum. It says the scope and the limitations of this inspection. The purpose of the inspection selected below is to discover any unsatisfactory conditions. And I know we touched on this last go around, but I want to bring it back just a little bit because some people have been contacting me relating to how broad this really is. So this language is much more akin to what's called a feasibility study. And what that, of course, means is that what we're saying is if anything is unsatisfactory to the buyer, an unsatisfactory condition, it doesn't have to be a defective part to the house. So let me give you the example. Inspectors will frequently, as you guys know, go through the property and note, okay, this HVAC heat exchanger is 7 years old. I expect that within 2 years it's going to die. Or this roof is 18 years old. I give it another 2 or 3 years and it's going to, need to be replaced. Under this inspection now, those items are not defective right now. The roof's not leaking and the HVAC system is working perfectly. But the inspector has stated that they have a very short life left. The question that has been presented to me is by other real estate professionals on this addendum is, well, if the item is still working perfectly, why does my seller have to repair it or the buyer can walk away? And the reason is because of this language. It says any item, let's use structural and mechanical, selected below is discovered to be an unsatisfactory condition. Unsatisfactory to whom is the question that needs to be asked. Well, that person is, or persons are the buyers. Unsatisfactory could mean anything. And it gives the buyers a much broader ability to escape the obligation under the contract to continue forward. Does that make sense to everybody? If there's nothing wrong with the, HVAC or the roof, but yet the buyer doesn't like that there's only a year to 2 years or whatever left, that to them is unsatisfactory. They can request the seller repair it, replace it, or they can get out. Does that make sense? Does anybody have a question on that? Okay.
Hey, Glenn, would a seller credit be okay in that instance?
Oh, yes. Yeah, another really good point. anytime any of these things happen, renegotiation is perfectly acceptable. Parties are free to renegotiate at any time during the process, whether it's subsequent to a home inspection, subsequent to an appraisal that might come in low, whatever the case may be, or just maybe one of the two of the parties wants to renegotiate. The buyers say, you know what, I'd like to renegotiate our offer because I can't settle on time. I need an extra 60 days, but I'll give you $5,000 additional. So that's a renegotiation. Curtis's point is exactly correct. There's a roof that maybe has a 2-year remaining life expectancy. So the buyer says it's unsatisfactory to me. The seller can go back and say, well, look, I'll give you a credit, right? We expect it's going to be $10,000 to replace the roof. 80% of the expected life is gone. I'll give you an $8,000 credit, right? And so the buyer gets the benefit of $2,000 use out of this roof until it has to be repaired. And then when it does, they've got the money. So it's a fair bargain for both parties under those conditions. So that's another great point, Curtis. Renegotiation is always a great tool to have in your pocket to use in these cases. Your clients, look, there's 7 different ways to skin this cat. Yes, this has happened, but your end goal is to sell this house. So let's be creative and look at renegotiating something that might work for all parties. Same thing with the buyers. You can save a transaction, which is ultimately what you want to do, right? You've got a buyer who's interested in a house. You've got a seller who needs to sell. The idea of your entire existence is about bringing those two parties together to a conclusion, to a sale, and leaving your mind open to renegotiating at any point in time, given whatever circumstances get placed in front of you. That is what you want to do. Be as creative as you can. If there's language that you need, by the way, there can be some creative language that we put into as-is addendums. Instead of using this particular addendum, I can draft language that may be more appropriate for your transaction, where your buyers kind of want as is, but they're okay maybe up to $5,000, right? They might want something that says, look, I can go as is, but if there's a noted repair on my inspection that's going to be more than $5,000, I want the right to renegotiate or to walk away. So we're not stuck, by the way, with what MAR says with us. I am your lawyer. I'm allowed to write all these contracts, and in fact, I contribute to the drafting of these documents with the MAR and the NAR. We can write anything that you need. Do not be limited by what's written in these particular contracts. They're guidelines for you in putting these deals together. They're pretty well done. For the most part, they're pretty well done, and they can get you home most of the time. But there may be situations that you want to play with the language in order to get your buyers or your sellers where they need to be. Don't be afraid to reach out and say, we need you to draw up a whole damn addendum. Not a problem. I've drawn up so many. I've got them in my file. We can usually take those out and tweak them to your specific needs. So great point.
I have a question.
Go ahead, Marcus.
So with the property addendum, and you're saying that if the buyer finds anything unsatisfactory, but if we sign that additional as-is provision addendum, would that cancel out if they find anything unsatisfactory?
Yes, in theory, right? You're not going to use a property inspection addendum if you're using the as-is addendum. And the reason for that is, right, this is truly as is, so an inspection is immaterial. So if you want a sort of combination of having a property inspection and maybe an as is, we can do that. We just have to use, I have to draft some different language for you in that, because really that's a great example, Marcus, of what is limiting about these two documents, and what the MAR has done here is they've limited a buyer's ability to be creative and say, look, I'm okay with as is, but I still want my inspection. Well, if you use an as is addendum, you're saying, I'm not getting an inspection. It is what it is, and I'm signing to that. And if I try and walk away or something, I lose my deposit. So, if you use an as-is provision addendum that's been here, you're not going to do a property inspection. If you want to do a property inspection, but also have some as-is provision, I have to draft some additional language in a separate addendum that you would use instead of these. Does that make sense?
Yes.
All right. Yeah. Perfect. Jasmine, I'm going to let you guide the line on time. I see it's just a little bit after 8. I can keep going for a bit if you like, but if you guys are tight on time, then I'm going to let you guide.
We can go for another 15 minutes or so.
Oh, okay, that's good. I talk too much. So there was another point that I wanted to bring up, and I lost it I had it just a minute ago in my contract. Let's go back to it. So on page, all right, let's first go to page 4 of the main body of the contract, if you could, Anita. Okay, page 4 and 19 and 20. Paragraphs 19 and 20. Actually, I'm looking at the wrong thing. Hang tight just a second. Sorry, guys, hang tight. Okay, so I'm sorry, I've got you on the wrong page, Anita. It's page 7, paragraph 48. Okay, and this is going to lead into something. We have a case that's brought up now. And it's been referred to me through Porterhouse folks, and it relates to title to a property, deed and title to a property. It relates to title insurance. It relates to unreleased liens, undiscovered liens. So I want to bring up a couple of points. Paragraph 48, most people never read, right? They're saying a deed and title. Okay, that just talks, maybe if you're talking to your buyers and you're going through the contract, or you're talking to yourselves and you're going through this contract, that just relates to transferring the deed and the title to the property. Boom, let's move on. Okay. So the problem is that there are some language specific to certain things in here, and that the sellers are warranting. They are making a warranty. They make the warranty in paragraph 48 to the buyers, and they make the warranty in the deed. And what are they warranting, right? Well, Maryland uses what's called a general warranty deed in most cases. In some cases, we use a specific warranty deed or a special warranty deed. They're the same thing. And in some cases, we use what people refer to as a quit claim deed. And in some estate or tax planning, we use a life estate deed. But here, and for almost all of your transactions, you're going to be using a general warranty deed. And if you look at paragraph 48 and you read it, and I encourage you to read all of 48, you're going to see that the seller is obligated to pass clear title to a buyer. Well, what does clear title mean, first off? Well, it means a couple things. Number one, that the seller is in fact the rightful owner of this property and has the right to transfer the equitable and legal title from themselves to the buyers. Number two, that there's no defects in the title, such as your neighbor's fence over your property line. That's a defect. An easement, a recorded easement that's not noted, and the buyers have no idea about. A unpaid property tax or a tax sale because the seller is an estate and the individual passed away maybe more than a year ago, property taxes have not been paid, and there's currently an active tax sale going on, and that is not cleared through the title. So what happens is when this deed is signed, then, pardon me guys, let me just let them know I'm calling them back. When this deed is signed by the seller and this contract is signed, the seller warranties all of these items. One of the big items that comes up quite frequently are income tax liens. Income tax liens are where the state of Maryland or the federal government, the Internal Revenue Service, has filed a lien against the property of an owner who has failed to pay some income tax. And it's usually years and years, and it can be quite a lot of money when that happens. So what our situation here is, number one, if your buyer buys a property and there's a federal or state tax lien against that property that nobody picks up at settlement, and deed gets signed by the seller makes no reference to it, and maybe the seller doesn't even understand that it's a lien, but they make no reference to it. Title transfers, and now the buyers own this property. A couple years down the road, those buyers want to sell the property. They're under contract, and title company number 2 says, whoa, there's a tax lien. So my question is for everybody, if the property's sold and the title company has issued a deed from one to the other, right? Then does that tax lien create a problem for the buyers? It's a tax lien against another person, not this buyer. Anybody have a guess?
I have a guess too.
I have
Go ahead,
to
Marcus.
get- Go ahead.
Okay.
Aurelia,
Uh,
Marcus, go ahead.
my guess is that I guess the title insurance would have to cover would cover that. And
Yeah.
and then it because the deed's transferred that the new if the title insurance doesn't cover it though, then that will be their problem because of the deed transfer, and that deed has a lien on that deed. It's not a lien on the person who sold it. Or whatever the
Yeah.
person that sold it, they're kind of like out of the situation now.
Guys, you guys are dead on tonight. You're hot. That's exactly right, Marcus. First off, the lien attaches against that title, that deed, and that property. It does not, it attaches against the person too who sold the property, the actual, a seller who owed the income tax. It does attach against them too, but it attaches against that property. So now this buyer's got a real problem. They cannot sell this property, and the tax lien might be very high, maybe over $100,000. And so it's got to be cleared up. Now, Marcus brought up title insurance. I cannot express enough how important it is and how critically negligent it is, where real estate professionals either don't advise their client to make sure they get title insurance, or where they say, oh, you can save a little bit of money by not getting title insurance. Because in this exact example, and it is close to our heart because it is referred to me from a porterhouse. This poor lady has no title insurance. None. And there's a lot of money at stake here. And so she's in a really tough spot, because the title insurance would have covered all of the costs of the attorney, all of the costs of court costs, all of the cost of the tax lien to pay it off. And this is an exact example of what because people will say, well, why